Everyone, with over 100 PFAS contamination sites in Wisconsin, we are certainly pleased to have all the panelists here today to talk about those issues. So we thank you. Let's thank the panelists for coming today. So we're going to just take a moment to have each panelist introduce themselves very briefly. Besides telling who you are, where do you work, or what do you do, what brought you, what reason did you want to be on the panel today? Start with Rob.
Well, I just talked, so y'all know who I am. But Dean had actually asked me to join this panel on Monday, so that is the reason that I joined. But very happy to do so, and I want to just say how encouraged I am by our elected officials being willing to come and talk to you all about that. It's really cool.
Hi everybody. My name is Peter Burress. I work as the Government Affairs Manager with Wisconsin Conservation Voters. I want to extend my appreciation and thanks to Clean Water Action Council for inviting us to join. And I also want to extend thanks to the panel here, Senator Cowles and Senator Wimberger. I know I've been working on this issue for a long time. Senator Wimberger, thank you to you in particular for your work to get funding passed through the budget. Senator Cowles, more recently, an issue that's related, but not directly what we're talking about today. Wanted to say thank you for being the one Senate Republican who voted to support the members of the Natural Resources Board, four highly qualified members of the Natural Resources Board. And it was a shame that the Senate voted them down. And Representative Palmeri, I just wanted to say a quick thanks for being in the Assembly, being new to the Assembly, and bringing such great local government expertise, and particularly appreciate the curiosity you bring to Assembly environment. It's not all of our legislators are good question askers and curious people, so really appreciate when they are, I would say. But we are, Wisconsin Conservation Voters is an environmental, nonpartisan nonprofit. We focus on engaging voters to protect Wisconsin's environment. We've been working on PFAS for about 6 years and very engaged in advocating for really getting our arms around this issue and supporting impacted communities.
Okay, and with that, we'll continue with brief introductions.
Yeah, sorry.
So you have a microphone. Yeah, these all work, so we don't have to pass.
So good afternoon, everyone. My name is Lori Palmeri, and I am a first-year legislator in the Assembly. I represent the 54th Assembly District, which is Oshkosh. It is not one of the greater impacted areas that we've seen on the maps, but I kind of came to this topic through my service on the City Council of 7 years and 2 terms as mayor, just finishing up a term this year. And so very interested in the topic as we started having constituents who, reached out to local councils and asking things about, are we testing? Do we have concerns? What about our fishing in Lake Winnebago? And so that's how I got, curious and interested. And I will say that this particular topic then also reaching out to our state representative at the time is in part what inspired me to run for this seat. So thank you.
I'm Eric Wimberger, Senator for the 30th Senate District. You're in the 30th Senate District right now. I guess long and short of it is I grew up here in De Pere, a lot of school, and then I joined the Marine Corps. I was a judge advocate in the Marine Corps, and then left as a captain in 2010, came back and set up my law office. I was doing that and kind of got, I don't know, when they're looking for good people, they ask you to do stuff, so now I'm doing this, and it's my first term in the Senate. For election again in 24. I guess my interest in, I knew PFAS was going on when I was first elected, but I think my interest was particularly piqued when the biosolids spreading, a constituent notified me that the biosolids spreading was recommencing with a known quantity in it. It was Peshtigo at the time. So Peshtigo had a known tested quantity, and nonetheless it was being spread, despite the fact that the neighboring community, Marinette, had decided to send it out on trains to a hazardous waste landfill. So I tried to dial that in. And since then, I've, along with Rob here, have kind of been on the front of the Senate together on this kind of issue. I'm on the Finance Committee, so I was able to do the convincing to get the money for it. But your penalty for doing good work is more work, and now we're drafting the grant program for it. But I think that kind of sums it up.
Greetings, everybody. Rob Coles, State Senator, 2nd Senate District. Why I'm here today? I was invited by Dean. But just a little history. Going back, it's probably 5 or 6 years, we didn't have standards. Representative Nygren, who's now retired, and myself asked DHS for a standard. Eventually, that led to the 70 parts that went through the DNR. That was drinking water. Surface water was a little bit less. We asked for standards. That was the first request. After that, we did the bills on firefighting foam, because after you have information, some scientific information, we knew that the firefighting foam was all over the state at various fire departments. And we did 2 bills, one restricting the use of firefighting foam, and a second one relating to we hired a contractor. We authorized the DNR to go out to RFP to hire a contractor, and they picked up maybe 60% of the firefighting foam. So along comes this bill now, which is a big bill to do a lot more things, to also revisit the firefighting foam. But I'm going too far, Dean. We can get into that. So anyhow, so I've been involved in this for a long time. Look forward to the dialogue here today. Thank you.
Thank you all. And I just want to comment, I'll go reverse here. Rob was invited because we know Rob, environmental work, and he also won an award. Was awarded Lake Michigan Day Hero or Water Hero at Lake Michigan Day recently. And we were very pleased that Senator Wimberger, his office had reached out to us to be on the panel. We were, yes, please. And we met Lori Palmeri, Representative Palmeri, at our banquet last year, where she expressed an interest in biosolids, PFAS in biosolids, which prompted us to write the issue of PFAS and biosolids. And then, of course, we reached out to Wisconsin conservation voters. We needed somebody from that side of the story to represent us on the panel, and they sent us Peter Burress. Thank you. And then Joel Kitchens was not able to make it, so we substituted Rob Lee for Joel Kitchens.
Your sandwich by Rob's here, just so you all know.
So, pair of Robs. Okay, so the way this is going to work, we had invited all of the panelists to submit questions, except for Rob, because and so we have some questions submitted by the panelists, but we also have a lot of staff questions, and we invited all of you to submit questions and ask. Didn't see. So it may be time for people to ask questions in the audience if there's and. But we have quite a few questions here. So let's begin by discussing SB 312 and the recent amendment. So what are your thoughts as to how well this bill and amendment will protect the public and the environment? Let's start with either one of our senators.
Well, if this bill makes it through the process, signed into law, it's going to, the DNR would be able to apply to the Joint Finance Committee on testing, because they may be running out of money. They're doing testing in a bunch of places, but the money is not indefinite. They could apply for money for remediation. They could apply money for grants to communities, and there's a whole flock of them around the state that are dealing with this. Monies for additional research. What am I missing? Some pilot projects. Is important to know. We put more money in the state budget thanks to Eric's help and a few others on finance than what was in the governor's. So the idea of this is that based on this piece of legislation, now it would flow back to the DNR to apply to the Finance Committee to get all this money out there to help the communities that are currently dealing with scientifically promulgated standards, of which there are 2 and more coming. but the monies would also be available for additional standards that are coming, and it was mentioned by Rob Lee and maybe Beth Neary earlier. Eventually the feds are going to hit us with a stronger standard. Eventually the state DNR is going to have a groundwater standard. Our bill would facilitate monies going to any of those things. Now, is it going to be enough? Get the crystal ball out. We don't know. So I think it's a very powerful bill that will help the communities that are currently getting hit with scientifically promulgated standards.
Let's, Senator Wimberger, did you have a comment?
Sure, but.
Okay,
whatever.
go ahead. We'll have you go, and then we'll have Peter Burress
Okay.
after.
Well, I guess the 50,000-foot view is that we're bound by Chapter 160 to adopt whatever federal standards come our way. Doesn't mean the state can't adopt standards, just that the DNR hasn't promulgated those standards. But the EPA is probably going to come up with a standard for groundwater, at least in the next year, probably less. And then we'll have to adopt that. So when that comes, we just have to be on the front end of being able to, I guess, deal with the waves, the ripple effects of all this. So the bill does a few things. I think importantly is that it gives grants to landfills and solid waste treatment facilities to treat leachate right there, then and there, to keep all of this at least localized at the landfill, and therefore preventing introduction of PFAS into biosolids to begin with. And that should substantially take care of a problem. Obviously, you're still going to have some stuff going down the drain pipe, but the high concentration that gets swirled around and then spread on your food is probably going to be helped out a lot with that. It helps with wells, so you can maybe drill a deeper well with a cased well or something, or different location, so that places in rural areas or farms in particular won't suffer too much. First of all, they have clean water to drink, but secondly, if you water your crops with PFAS water, you are actually, by the spills law, spilling a hazardous substance. That was one of the things we had to take out with regard to municipalities, because it's exploding the budget in places like Marinette, who used to be able to drop a pump into a pit and just pump water out. Now they have to pump it into a tanker and take it to the treatment facility. So we were going to try to come up with an exemption there, but federal law is going to require that sort of thing. So to at least make it so you can get a new well, and so a farmer doesn't have to treat everything that comes up, or stay in business, period, I suppose, at least help with that. But I guess, generally speaking, the liability protections are important. Ask yourself, would you, and this is what is talked about with restricting DNR authority, and that I think is not only good but unnecessary for us. Would you buy a property that was subject to remediation orders? The answer is no. Even if the DNR does not decide to order you into remediation, you will not buy a property subject to remediation orders, because, like in the previous presentation, Mouthy and Chrysler outboard mean that any owner, no matter how it got in there, is going to be responsible. Concept being, you buy the property on day one, you are not an emitter of a pollutant, but the first molecule that then migrates off is a new pollution, so to speak, that molecule migrates off. So no one's going to be buying those properties. So a farm that has it on there, asset loss, plus they can't function because of the water coming out of the well. Any sort of like, if you're in Marinette, that's what, 3 miles to the bay from Johnson Controls? That whole pollution plume and everyone in it, now we're zero. So it's really important to do that. Plus, property values are zero. Guess what? The tax base is zero for that area. It's a personal tragedy. It's a governmental tragedy. It'll be abandonment of property is sheeting back to the state, and the state has to take care of it anyway. So the idea here is liability, or I'm sorry, orders to remediation will be not permitted, as long as you let the DNR go on there and do what the DNR needs to do to solve the problem or test or do whatever. So it's not like you don't have to do anything. You do have to let the state on your property to try and figure it out and test. It does not apply to the original point source. So this is all innocent landowners who could be a mile or more from the original contamination. So French Island, Stella, that kind of stuff, Peshigo, or anywhere else. Overall, that's also an important thing because we don't know where this stuff is. I have an Excel spreadsheet with 13,000 locations, hundreds of acres at each location, where biosolids have been spread in the last 20 years. And DNR hasn't been keeping track of the PFAS concentration. So if a person or a farmer or someone near a farmer is curious about their health situation, if they have to make if they're faced with the dilemma of trying to figure out their health situation and their water situation, or having their asset they stuck all their life's work into devalued to zero, we're not going to find out an accurate map of all this stuff. So I think on the whole, that's sort of a scenario that Rob and I have come up with is going to be an important one. Helps people come up with solutions and actually a better way to detect the problem and maybe contemplate a path forward.
Thank you. Conversely, let's hear from Peter Burress. We receive emails from Wisconsin conservation voters expressing concerns with SB 12 and then also with the amendment. So what comment do you have?
Yeah, thank you. So we oppose the version of SB 312 that the senators voted out of committee. And I think a big part of this story that's missing from this conversation so far. So when we think about action on PFAS, we think about kind of three key principles broadly that we need to be focused on. So that's first, health and impacted people first. So we haven't talked too much today about the communities across the state that are living off of 5-gallon water jugs. Folks that are brushing their teeth, washing their dishes, mixing their baby formula, watering their plants with 5-gallon water jugs because they can't trust the water coming out of their tap. And so anything that we do in the capital, at the local level, the state level, the federal level, needs to be rooted in community action and the health of people first. Second, we are really excited about the funding that was passed to the budget and want to see it go out the door as quickly as possible, and are really frustrated by polluter loopholes attached to the legislation that would really shift many of the potential benefits of this funding from specifically private well owners, which we understood to be the original intent of the legislation, to commercial and industrial properties, some of which might be responsible for the contamination. So we need to be focused on impacted municipalities and impacted private well owners, a third of Wisconsinites, and get that money to them as quickly as possible without these limitations on the DNR. And third, as a key principle, we need to be focused on standards in our state and preventative action. And those aren't a part of this legislation. And that's okay. We can have that conversation separately. We said that from the front end, that doesn't need to be part of the conversation. But the other side of that shouldn't be part of the conversation either. There shouldn't be these limitations on the DNR. So that's where we are, and happy to share the specifics, the particular language in the bill that we're concerned about, because I have it underlined here, and we've reached out to the senators about it. But that's why we oppose.
Okay. And I have a follow-up question that's going to Rob Lee. I haven't forgot about you, Representative Palmeri. I have a specific question for you coming up. But this question is for Rob. The recent MEA newsletter has a subheadline that reads, in part, "The bill contains troubling provisions that limit the state's authority to hold polluters accountable." What are those troubling provisions?
Well, I think they're the provisions that Senator Wimberger and Peter here were just alluding to. I think the most problematic one for us is in 9.4C, which is an enforcement action limitation on the Department of Natural Resources. And what I think the point that I want to convey is to reiterate what Peter was said, to just get slightly more nuanced about it, right? I think if the idea is to encourage property owners to allow DNR to come on to their property and test, right? So that we're aware of the problem, and particularly if their property isn't contaminated through any fault of their own, right? If it merged onto their property and DNR wants to know. Now, we already talked about there being an exemption for that, but I think there's something to that, right? And I think there is perhaps even a middle ground with just respect to that. But my problem is when I read Section 9 but 9.4C in particular, is that I'm also reading it with the context of all that litigation that I've talked to you about. And I know how responsible parties will take the words on the page and twist it in litigation and try to leverage that to go far beyond that discrete problem that the senator was talking about. And that's really the concern that we have. If there is a reasonable or an appropriate limitation on DNR's authority, fine, right? But the bill should say that and only that, and foreclose the possibility for somebody to get in there and potentially explode some of those limitations on DNR's authority to go far beyond what may have been originally intended there. So that's why we see the potential in there, whether or not it was intended, right, or by the words on the page. Certainly our principles of statutory interpretation would give rise to different arguments about what that means, and they certainly could be accepted by a court. And so it's that risk right there, and the potential to really frustrate some of those goals of the spills law that I talked about before, and the fact that if exploded, right, could far outpace the money that we've set aside right now. So that's the concern with that provision in particular. I think there's some other concerns, but that's really, I think, the heart of it right there. And I certainly want to be in a place where we're trying to give DNR more tools, not fewer, right? And I think there's a lot in the bill to commend, but certain aspects of it that, unfortunately, as drafted right now, overcome the benefits, unfortunately.
Thank you, Rob. I have some other questions, but let's give our senators a quick response. Time for a response to those two comments.
Yeah, I think it's I think that's misreading. The innocent landowner section is spelled out. It's who qualifies as an innocent landowner, and the language used is platitudinous to make you believe something is happening that isn't. So when they say hold polluters accountable or lose polluter loophole, they're calling somebody who just happens to own a property and is emitting a polluter and restricting the DNR's authority to hold polluters accountable. And in the largest macro kind of a mischaracterization or to categorize things, it's a semantic sleight of hand to say it that way, and you raise money that way. That's all. I don't think that there's any way to interpret anything except for if you are an innocent landowner, somebody who just happens to have PFAS floating through their property, that the DNR won't come in. By the way, the reason I get sharp at this is because the DNR to this day still biosolids spreads, and I've written so many letters. I have asked for so much rulemaking and testing. 292 grants them all this authority to do that. They don't even start. They don't even do anything to test. So up to 150,000 parts per trillion can be, and they use this as a guideline. 150,000 parts per trillion can be in the biosolids, and they can apply 10,000 gallons of the wet stuff or 1.5 dry tons of the dry per acre. At 150,000 parts per trillion, it's going to sink into the ground, and then then they're going to tell you that you have to remediate and do all these wells and do all these things and shut down your farm because you pop hot in your well at 20 parts per trillion. It's an obnoxious method to control using the cases of Mouthy and Chrysler, because they know darn well it doesn't matter how it got on there. And then coincidentally, in 292 is a sovereign immunity clause that prevents anyone from suing the state or the municipality where they got the biosolids, which I'm not necessarily opposed to the sovereign immunity part of it. But that creates this dynamic where the person at the end holding the bag is that innocent landowner. So if there's something specific in there that can be written to exclude a manufacturing facility where the pollution plume is there, if that's particularly needed, Rob and I and everyone else on the bill is certainly open to that. However, the plain reading of it says exactly that. So when holding polluters accountable, when they incorporate into the definition of polluter some innocent landowner, that's a big problem for me.
Sounds like at this time we should talk about biosolids. Let's go to Representative Palmeri. Question is, what legislative efforts do you believe are needed to protect the public from PFAS contamination in biosolids, from contaminating our soil and water? Is there legislation that's needed so that administrative rules can be promulgated to protect the public and keep the DNR from spreading what I just heard was 50,000 parts per trillion biosolids on land? What do you think?
So yes, and I'll just say that this conversation started actually back in 2020 for me. It was my first year after being elected mayor, and started having conversations about some of the costs of disposing of the biosludge from our wastewater treatment plant. At that time, I had been hearing some of the media things, starting to listen to some of the technical advisory PFAS things, and it was a difficult conversation even at the local city council level to even talk about educating our council members and our public on this whole thing, right? Let alone the biosolid application of land to the west of us as what seemed to be a beneficial opportunity. It was low cost to the city to dispose of that, and the farmer, was gaining this fertilizer benefit. But then as we, started to kind of peel this onion that is PFAS, PFLA, and the myriad of the forever chemicals, it became really frustrating that municipalities and townships and organizations didn't want to do the testing because they were afraid of, maybe what they might find or, what could be done beyond that. And so, yes, I believe that we need to, there was a report from 2021 from the DNR called the Interim Strategy on kind of dealing with these biosolid land applications. And there are a number of recommendations in there. But if they don't have the ability to move forward in some of these things that are needed, if they're restricted to have to constantly go back for every little piece to a specific committee who may arbitrarily, make the decision not to grant that, it just seems really frustrating. But I believe that we do need to have product and packaging testing. I think some of our neighbor states, like I believe Minnesota, have come up with some guidelines that are really specific about what's essential use versus what's not, where it can be, because we know that are used in a way that make our modern society function. It's a question of, to what degree do we drink this poison? So that's how I feel about it, that we need to have the biosolid testing, those product and packaging, protecting the consumer. I mean, who who here knows, you go to Target, what kind of cookware to buy today? Are there labels that tell you, PFAS free or not? Or I think we heard this morning about some different water filters in that. So I think right to know legislation is important.
Going to move on to another question, and I'm going to come back to Lori's final comments because I had a end of the session question about that. But let's go to Rob. I think being an very experienced legislator, being in the Senate for quite a few years, maybe you haven't thought about this. Why did it take so long to moving forward the bill? It languished all through the summer. We thought, the PFAS conference, we'll have an answer to what the bill is going to be. It'll already be passed. It'll be a done deal. But it still isn't. Can you tell us about that? Why did it take so long?
Well, politics is always the art of the possible. And near the end of the session, the budget session, DNR wanted to keep talking about some of these fine points. Now we're down to discussing one point, the authority to go after something that doesn't have a standard. I think Eric would agree to that. We've given them 80 or 90% of the things and we've had 14 meetings with the DNR staff and us and our staffs. And I think that Secretary Payne was in half of those. I'm sorry he's left in a few days, by the way. Exactly, they wanted to talk more. We want, it's a complicated bill. Would it be nice to have it done in July? It would be nice. But I don't think he'd look at this as like the last thing that's ever going to happen. I mean, this is an evolving thing. Professor Neary talked about studies earlier today, and we've talked many times. There's going to be new information coming out, and we might have to adapt things. But if we know that there's a problem with these two substances and a bunch of drinking water systems are grappling with it, why wouldn't we get that done now? I mean, that's the way I look at it. I mean, is any legislation perfect? It's never perfect. There's always something that has to come back at another time. So to let this go now, I know what the two gentlemen on the end are saying. They're concerned about the spills law. But we don't think that we're pretty sure that this does not intersect on the spills law. So
The arc of this, I would think, would be that it was very aspirational to try and get this done by July because you get the money awarded and you want to come out with something, but just there were 35 parties that had registered on this.
yeah,
So to find some, in each one of them came with particular issues, and we're not just talking about creating a grant program and helping people, whatever. It all how it functions, how it might be altered in one way or another by the supremacy clause in the United States Constitution because there's an EPA rule here, and this and that applies there. So it just turned out not to be possible by July. But we weren't going to come back into session here until the fall. So here we are, and that's why it was that delay. But it probably didn't happen in October, I would say, because some of the changes we made everybody mad. so we're probably going to remove some of all of that, and everybody should be happy, right? But I'm confident it'll get done in the next couple of weeks. Right? I mean,
through the Senate.
Yeah, through the Senate at least.
Thank you. And just so all the panelists know, you will have a brief time at the end to make a final comment. So thinking about something you need to say, write it down. I'm going to address this to all the legislators here. When it comes to PFAS, how do you decide what aspects of the issue to prioritize at the Capitol? Are there specific people or groups that you look to when deciding what to support or not to support?
Let's just start. Drinking water. We all drink all day long. We have a standard. And by the way, the bill, I think Peter mentioned, the bill does not preclude us taking some of that for the agency applying to the Finance Committee to helping well owners. So that's part of this. Is it enough money? We'll see. But drinking water is number one, and we have the standards. So there's some 14 communities that are applying for the Safe Drinking Water, the revolving loan fund under current law. They're applying, they're going to get some money. Their rates are going up. This bill is passed, we're going to be able to suppress those rates. Those communities are going to be happy about that because they're going to be paying a lot more money from, look at Wausau. Rates are up 65%, I think, and a number of other situations. So for me, drinking water.
I would say that I don't think we've ever talked about priorities. I think it was kind of accepted that the primary thing to do first is to get people safe drinking water. Then after that, find out how to pay for that. And then for me, I guess in that triage list, look for the long-term solution and to maintain that sort of collateral effects, prevent those other dominoes that I was talking about before from falling on people. But first and foremost, how do you deal with the exigent kind of immediate thing first? Yeah.
Well, I think that at the same time that we're reacting to what already has happened and what already is impacting communities and people and drinking water, we also have to protect future generations from further and this, I guess, long-term phase out of the use of the products and eliminating it from doing the damage that it is. I think that you can't say either or. You have to do both. It's an and. People and folks who are trying to make decisions about their health have to be informed, and they also have to have an opportunity to be part of this. As a first-year legislator, and I'm assigned to the environmental committee, and so we've kind of been waiting to see, what was going to come back in the amendments in that. So it's very challenging to, again, be asked an either or, but really this is an and.
Thank you. We're going to move to Rob Lee now and talking about the spills law, and kind of in two parts. Do you see any threat from, as Senator Cowles said, he didn't see that the bill was going to threaten DNR's authority over the spills law? And I guess I'm wondering, what's your thought on that? And what if this ends up being lost at the Supreme Court? The DNR loses its authority over the spills law. What are your thoughts about that? Where do we go from here? We need legislation to undo state Supreme Court ruling if that was the case.
Well, I think the senator's right that it doesn't directly modify, for example, 292.11.3 that I showed earlier that imposes those two requirements on responsible parties. But what it does is create an incentive to those who may be responsible parties to not do those things if it were to deny DNR of the ability to enforce the law against those responsible parties, right? If there's no risk of you being prosecuted for not fulfilling those responsibilities, right? That's where DNR's lack of enforcement authority can become problematic. Right now, they haven't had to really bring that many enforcement actions, and when I say that, I mean not their stepped enforcement, like here's a notice of violation, but like a lawsuit to, or civil prosecution. They certainly have against Tyco and others, but so that's that, and that's why it's a little. When you read it on its face, it may not be as readily apparent, but when you start to think about how it could play out in application, is where our eyes sort of get really wide, right? And I very much support, right, trying to get relief to people who may be liable but aren't culpable, like we talked about before, right? But it can't just be a straight up exemption or a disincentive to do that, right? We have to make sure that there's something in its place to get those properties cleaned up. And while there is some funding in this bill, right, it's going to a whole lot of different sources, right? And again, that's why not suggesting the senators intend with that language, but it's that risk, right? And that there. So it's always more nuanced than that, Dean, but just kind of in a nutshell. And then your question about the spills law case. What was it that someone said earlier is always the response? It depends, right? It really does depend on how, first the Court of Appeals, right, has to rule on that case, but they could decide it along a range of outcomes, right? They could say, no, DNR is under solid authority. They could say, DNR, you not only have to pass a rule saying this is a hazardous substance, you have to identify the concentration at which, like in particular media, it becomes hazardous, right? Yeah, or no rule at all, right? Say we have that narrative standard right there in statute, but it certainly depends, right? If it's that more pollutant and media specific, like numerical concentration holding, I think it becomes highly problematic and impossible for DNR to try to fix that through a rulemaking, and it would have to be fixed to some extent through legislation with that, right? Because just because of the large impacts there and the inability for DNR, right, to address all of those contaminants in a reasonable amount of time, right? They would basically be left to try to reenact the spills laws that currently exist, right? For all contaminants. And that's another way that case could go, right? I mentioned earlier there's the PFAS specific claims, but then there's that fourth very broad claim that could apply to virtually any substance. So there's just a range of outcomes there that at this point are too kind of uncertain to predict. But some of the solutions you mentioned may very well be needed.
Thank you, Rob. I have just one more question, but I'm going to combine the question with kind of your final comments because I see we're kind of running out of time. So since PFAS chemicals do not easily break down in the environment and is extremely difficult to remove them from our waters, what action do you think the state should take to keep PFAS out of the environment? For instance, the Colorado House Bill 22-1345 limits the addition of PFAS in many, many products. They've passed that bill. Many products now cannot have PFAS in. What do you think the state should do? Then any final comments that you have? We'll start with Peter.
Yeah, so I think this goes back to, we've been trying to be crystal clear about what we want the state to be doing, which is getting the money out the door without these poison pills attached, and then working on long-term prevention, so phasing out non-essential use of PFAS in our products, and setting health-based standards. So in terms of kind of final thoughts, I want to go back to the community piece because I think process really matters here as well. And the way that we do our work is, as a lobbyist in the Capitol, anytime something moves, we see a new version of something, we go back to our members and our partners, specifically our PFAS partners, who are about kind of 25 folks from across the state, combination of local electeds, living in impacted communities, public health experts, hydrogeologists, environmental lawyers. It's a really great group of folks, geographically diverse in terms of backgrounds with the issue, right? So, and we say, what do you think of this? And that's what shapes the way that we take positions and the way we engage in the Capitol. And what we've heard about this process, this session, is that folks are confused about what's happening and frustrated and worried that what is being worked on will leave them behind. And so I just can't underscore enough the importance of bringing impacted community members in and centering them first before stakeholders who, like Wisconsin conservation voters, who spend a lot of money lobbying in the Capitol. It's got to be impacted community members who are dealing with the issue. So yeah, with that, I appreciate the conversation today. Thanks again for having me.
Lori, would you like to go next?
So I guess, really, again, coming from this unique perspective of having served at the local government level, being a neighborhood activist, living in a not quite urban, but a not quite rural community, grandmother, mom, these, I guess, consumer issues are really of concern as well. Everything that has been said about drinking water is really important. But in addition to addressing that at the state level with these measuring and monitoring and remediating, we also have to look at informed decision-making by folks, right? And you can't do that if there's not the correct testing and the information and the labeling and I guess, questioning the necessity of some of the applications for us. And so I really hope that, these pieces of legislation can lead into, as Senator Cowles was mentioning, a series of things that will comprehensively address this both proactively, reactively, and proactively.
And Senator Wimberger, your thoughts on protecting environment,
Sure.
PFAS, and your final thoughts?
Yeah, I think phase out is just fine. The immediate shutting down of it causes those secondary problems. Like, for instance, right off the top of my head, the rewinders at your paper company have it on there. So just as a necessary application to rewind paper and toilet paper. So I mean, suddenly that's gone instantaneously. So there has to be some sort of phase out, and the DNR recognizes that as a way to deal with problems like this. And they're not going to shut down your sewage plant, for instance. What they'll do is they'll set standards and monitor and kind of guide you down, try to find the people who are putting it down the drain pipe and that sort of thing. And there are efforts just like that throughout industry that can probably be done over the course of time. And I don't think there's going to be any opposition to that sort of an idea in the legislature. But I do want to kind of reinforce that you don't have a right to conduct industry. And your privacy rights are diminished when you conduct industry. And there just simply has to be a rational basis test achieved in order to abrogate some of these limited extensions of rights to industrial activity. So even if Section 292 were to limit this or limit that, as a condition of getting a permit for doing any industrial act, you can demand that there be this testing. So to hyper-focus on, well, we need this particular authority or else, I think is kind of misplaced. Because all that you have to do is simply say as part of your permitting to conduct any sort of business activity that you have to test for this if it's a part of, if you're dealing with those types of chemicals or anything related to those chemicals. I do have a different take on the Jefferson County case. I think that the question was not whether there needs to be a standard. The question was, having a spill been discovered, in order to remediation needs to have a level set to it. Because if you're ordered to remediate, then remediate to what? So if there's not the connection between the spill, the order, and the result, then the demand for the action of to clean up to what, is an arbitrary and capricious demand by function of constitutional law. So you don't necessarily have to have a standard to order someone to remediation. All the DNR has to do is say, according to this study, such and such a content is dangerous, so therefore we're going to order you to this standard. I think the flaw in the Jefferson County case, which I don't know why the DNR doesn't understand this, I've talked to them, is just study the topic, come up with a standard, and it seems to be quite low, 20 parts per trillion or less nowadays, and then have that connection to create a rational basis so it passes the rational basis test. You don't need a standard necessarily, but you do have to do the legwork. You have to do the work. So I think the WMC won that argument because the DNR said, well, we just want them to remediate. Till when? Till what standard? And I think that was the flaw in that case. I think also to understand it in this kind of a dynamic is when we talk about rules and regulations, I want to say it's, Article 3, Section 9 of the U.S. Constitution. But there's a prohibition in the Constitution against ex post facto laws. So if there was a violation of the law and there's no rule promulgated, and now you then want to promulgate a rule or create a statute, it's ex post facto. You can't hold someone accountable to it, and that's what's so important about this rulemaking. There's also a prohibition in that same section for bills of attainder. Bills of attainder is just by a statute declaring someone responsible. That was such a problem when the Constitution was created because Parliament used to just declare what somebody did yesterday that they didn't like a political opponent. They just declare what he did yesterday illegal, then put him in prison or have him executed. So those bills of attainder are prohibited as well. So you can't just hold polluters accountable by statute. It has to be done by the courts to the rules that were applied at the time of the violation. And just in that in the ether there, trying to craft a solution. That's why Rob and I kind of take these tactics we do, because we know the limitations within the law and what's constitutional. At least, you can always parse out language, I suppose, or try to come up with theories in any sort of statute when you're litigating it. But that's kind of the idea of it. I think what needs to happen the most is an understanding of the DNR's role here, because there's 10,000, 15,000 PFAS chemicals. Add another molecule or atom on the end, you add a different one. That the whole reason we create the structure of administrative law is so that the state can be malleable in its response to what a quote-unquote hazardous substance is. Because think of trying to get 15,000 different statutes passed, let alone 15,000 different rules for these substances. So it's infinitely more difficult that way, because Rob and I aren't scientists studying this. We don't know what's healthy or not healthy. So we rely on this rulemaking authority to do that, and they have to promulgate these rules. I think the main failing in the last few years has been an aversion to doing the legwork within administrative agencies to create the nexus between the rule and the purpose and the outcome to pass these rational basis tests and then go ahead and do these things. But then again, also this bill, one of the things it does is it helps fund coordination between the DNR and UW to actually come to terms with that. Overall, the bill doesn't necessarily apply money to particular things. It actually says this is what we want to happen. The DNR is going to come back to the legislature through the Finance Committee and say, well, after looking at this, we think we're going to need $10 million for this, we're going to need $15 million for that, and then we'll take a second look at it based on what they come up with. And I think that we've made a good start here.
That's
Thank
quite
you.
a summary.
Senator,
Thanks very much for inviting me.
Senator Cowles, thank you.
Thank you very much. I've been involved in environmental politics for a long time. Sometimes it feels that way. Sometimes it feels very fresh. And I think many of us remember, there's a few people in the room who remember the mercury issue. Well, people figured out ways to not have mercury in their products. They purchased different things. Eventually, there were various bans at the federal level. It's one of those kinds of issues. I think Lori talked about products, getting rid of products that have the stuff, because wouldn't it be nice if it's just not in the environment, so we've got to figure out how to capture it and contain it. So to the extent that we can find those products that don't have it, that's a great thing, because it would be very difficult for us to pass product bans at the state level. I think it's more likely to be effective if it's at the national level, but I'd keep an open mind to that. I know that there's a company it's the old Tilmany plant out of Kaukauna. It's now owned by Yakapori, and they're pretty advanced, and they're generating products that are PFAS free great for them. Let's buy their products. And I heard today that McDonald's is generating products, and so on and so on. So I think that's a way to fight back on this, to diminish PFAS of different types in the environment. But it's an ongoing issue. We think we have a good bill, and there's a couple of amendments. I want the gentlemen on the end that have some issues with the bill to look at those amendments when they're available. I'm not sure when, next week perhaps. It's never going. I just want to say this again. It's never going to be perfect. The legislative process is difficult. So thank you again for having me, and thank you for your advocacy. Thanks, Dean.
And let's thank all of our panelists at this time.